Reckless driving is on the rise across Wisconsin. From Milwaukee to Green Bay, crashes and near misses are raising urgent legal and policy questions. Assistant City Attorney for Milwaukee, Alex Miller, and Attorney Alexander Sandy Pendleton of Pendleton SC explore how reckless driving laws are evolving, the tools communities can use to respond, and why every lawyer, regardless of their practice area, should pay attention. I'm Peter Kramer, Digital Communications Coordinator with the State Bar of Wisconsin, and I spoke with both of these attorneys in June at the 2025 annual meeting and conference. Join us to see how legal professionals can help shape smart, effective solutions and restore safety and trust on Wisconsin's roads. Reckless driving is something that I think everybody is becoming more familiar with in Wisconsin. And I wanted to start out by asking you why this was a topic that you felt strongly should be addressed here at the annual meeting.
So I'm a business attorney. I'm a business litigator. I don't do criminal law. I don't do traffic violations or citations anytime in my career. But I am a person who drives around in Milwaukee and my community, Shorewood. And it's just so obvious that the problem of reckless driving is on the rise in my area. Since COVID, it has become a much bigger problem. I've been a longtime advocate for safer streets, and getting a grip on reckless driving, I think, is so important for not just Milwaukee, but all of our communities. Because I really think that, reckless driving, it's not just dangerous. It's not just dangerous to the driver and the occupants of that driver's vehicle. It's dangerous to everybody else who's on the street and everybody who's on the sidewalks. And we're going to come to a place where people are like, why should I live in Milwaukee or Shorewood Hills or Madison or Green Bay with all of these reckless drivers who are endangering me, my children, my families? Why should I have a business here? Why should I accept a job here with all of these reckless drivers around here? It's corrosive. Reckless driving is corrosive, highly corrosive to that sense of safety and order that makes people want to choose to live in a community or go and shop or go to events in that community. We need, as a society, to get a grip on reckless driving.
What were some of the things that you covered in today's session?
Well, the session was focused on reckless driving, of course, painting the picture of the cost of reckless driving for certain communities in the state. And then once we had done that, talking about legal strategies and legal challenges in trying to address reckless driving. So my portion of the presentation was kind of focused on enforcement and prosecution of reckless driving behavior, challenges associated with that, whether that works as a deterrent, and talking about also the use of vehicle impound laws by municipalities.
So we know that reckless driving incidents have been increasing across Wisconsin, especially in some of the larger cities. From your perspective, what are some of the patterns and the root causes behind that, and what should lawyers really know about these kinds of cases when they hit their desk?
Yeah, reckless driving is a big issue, especially in the city of Milwaukee, where I practice, and comes with an immense cost. The statistics bear that out, and one data set you can look at when you're trying to gauge whether or how serious this issue is looking at the death toll. And when you look at the death toll, traffic fatalities in the city of Milwaukee, you see that this is a really extreme problem. In 2019, there were 56 traffic fatalities within the city, and the numbers have only gone up since then. The highest was in 2020 with 77 traffic fatalities. And when you look at these cases with more granularity, with more scrutiny, you find that most of these cases either involve illegal speeding, disregard of traffic signals, inattentive driving. So most of these deaths you come to determine are entirely avoidable, right? And those numbers are just the fatal traffic accidents, which are minute when you compare those with reckless driving incidents that result in non-fatal accidents, that result in property damage. So the cost of reckless driving in the city of Milwaukee includes unnecessary loss of life, significant costs to individuals, to taxpayers, and to businesses. So yeah, this is a big problem. What's driving this problem? One thing we noticed in Milwaukee, at least, is that there is a small group of really egregiously bad drivers. And those individuals seem to not be deterred by receiving additional traffic citations. Issuance of traffic citations is the main tool that a municipality has to deter bad behavior on its roadways. But when you're dealing with a small group of really bad drivers who doesn't seem to be deterred by fines because maybe they just don't pay the fines, or not deterred by the demerit points associated with traffic citations, because demerit points only matter if you intend to have a valid driver's license at some point, which many of these individuals do not. How do you go about deterring those people? Well, one idea that we had in Milwaukee is to try to increase the repercussions that they feel. A bit of context, the Milwaukee City Attorney's Office had a recent change in leadership. In April 2024, City Attorney Evan Goyke took office. He was elected. And right away we sat down and began to discuss whether there was something more that we could be doing to address reckless driving in the city, because it is kind of a paramount issue for everyone in the city, whether they live in the city or just visit with any regularity. Everyone is kind of affected by this issue. One thing we noticed is that there were additional opportunities provided by a state statute with regard to the penalties. Reckless driving is prohibited under 346.62 of the Wisconsin statutes. The penalty section is found in 346.65. And that statute was amended in 2023 to allow for greater repercussions in the case of repeat reckless drivers. So the state of the law now is that a repeat reckless driver, someone who has a prior conviction under 346.62 sub 2, can be charged criminally for a second or subsequent violation of that law. So there we saw an opportunity to create greater repercussions for these repeat offenders if we just changed the way we did business to some extent. So we gathered with the police department, with the DA's office, and focused on making sure that we were prosecuting reckless driving under the statute vigorously. So traffic officers were trained to refocus on issuing citations for really egregious driving under the actual reckless driving statute, as opposed to maybe some alternative statute. For the city attorney's office, for our part, we focus on achieving convictions under the actual reckless driving statute. And then, of course, the DA's office agreed to charge second and subsequent violations and vigorously prosecute those in circuit court. So that was the idea. That was announced to the community at a press conference in October of 24. And since then, we've been prosecuting more reckless driving behavior under the actual reckless driving statute, securing convictions, and we have seen repeat offenders getting charged in criminal court. So, that's one way that we've gone about this.
You spoke a little bit about some of the automated systems that are out there. Could you kind of give us just a brief overview on what some of those are, what are the legal issues around them, and what should attorneys kind of be keeping in mind?
Right. So let's first talk about outside of Wisconsin, because right now there's no community in Wisconsin that are using automated traffic enforcement systems, right? But the a majority of the states, it's somewhere between 20, 25, 30 states are using, or communities in those states are using automated enforcement systems to enforce their traffic regulations. Red light cameras, speed cameras. There's something like 600 communities now across the U.S. that are using these systems. Nobody in Wisconsin is using these systems right now because of the way our statutes, our traffic statutes are written. So there's an argument that could be made that if there's a community in Wisconsin that really wanted to push the envelope and kind of go it alone and start using these systems, that they could, especially involving school crossing, safety guard regulations, because unlike most regulations in Wisconsin, which require the prosecutor to prove, this is the guy who was operating this vehicle at the time. Our school crossing rules, our statutes are created such that the citation can be issued to the operator or the owner. And then the burden is on the owner to come in and say, it wasn't me, it was this person I loaned the car to, or the car was stolen, or the car, there was some other reason why I shouldn't be responsible for this. It shifts the burden. That already exists. That's a tool communities could use if they want to make school zones safer for kids and parents, our most vulnerable road users. But when it comes to just everyday run-of-the-mill speeding, everyday run-of-the-mill red light driving, and I say that kind of casually. I mean, it's blatant, it's brazen in Milwaukee. People not even slowing down, not even looking, just going through red lights, going 70, 80 miles an hour in a 30 mile per hour zone. We see that. But right now, the way Wisconsin law is structured, it's the obligation of the prosecutor to prove this is the guy who was operating, and therefore that person can be held liable.
Speed and red light cameras have been adopted in other states and communities, but not in Wisconsin. So I wanted to ask you, what are some of the barriers that stand in the way of that, and what due process safeguards need to be built in?
Barriers to speed cameras. Well, one is a state statute, 349.02 sub 3, which outlaws specifically the use of radar speed enforcement cameras, right? So I think many municipalities have read that to simply prohibit speed cameras. Obviously, my co-presenter, Sandy Pendleton, made the case that it does not prohibit certain types of speed cameras. But still, the fact of the matter is, perhaps that is a reason for the fact that they are not currently in use in the state. And of course, radar was, the primary method of measuring speed until somewhat recently. So that might be a reason for the fact that they're not in use. In terms of barriers to using them, aside from what I've mentioned with regard to the statute, one would have to take into account that the type of evidence created by a speed camera may require either really advanced technology or a change in the law. With regard to the current state of the law, speeding is only illegal by the perpetrator of the speeding, and so that is to say the driver, not the owner of the vehicle, right? If I borrow your car and I speed in it, I'm guilty of speeding. You're not guilty of an owner's liability speeding offense. There's a set limited number of offenses under the Wisconsin statutes that hold a vehicle owner liable for the bad actions of whoever happened to be driving your vehicle. Speeding is not one of those. So a speed camera would either have to be so advanced that it can get my face, and then that can be I could be prosecuted for the speeding offense, if I could be identified, of course, or there would need to be a change in the law to, create some new owner's liability speeding offense, which doesn't currently exist on the statute books.
Some of the automated and impound strategies that have been proposed out there have sparked some debate about revenue generation and equity issues. So my question to you then is, how can policymakers and lawyers frame these programs to address some of the concerns that are coming up?
So I really think we should look to other states. We should look to other states that have implemented these systems in a less than ideal way, and states that have learned from those mistakes and those problems and implemented these systems in a much better, fairer way. In our presentation, we referred to Automated Enforcement 1.0, which is sometimes referred to as the Chicago model, and Automated Enforcement 2.0, which you would then look to states like Connecticut or Colorado, which have taken a dramatically different, and I would suggest more intelligent, smart, fairer approach to this system of this issue of automated enforcement. For example, in Chicago, what is it? Something like $1 billion in fees they've collected, and that's done on a contract basis with the supplier of the technology that is contingent fee based, right? Creating incentives for the supplier or the community, and also the funds go into the general funds. So if you're a local elected official and you say, boy, we got this huge budget, black hole we got to fill, it can be real tempting to say, well, let's dial up the cameras so we're catching a lot more speeders, catching a lot more red light runners. And that really creates a distrust by the community into what's the real motivation to adopt these systems. Is it merely just so local officials get a lot more of our hard-earned funds, or is it actually to make our roads safer? So in Connecticut, the Model 2.0, very different approach, right? The money can only be used to pay for the equipment, right? Can't use contingent fee contracts, and can only be used for road safety education and to improve the roads. Traffic calming measures. Traffic calming measures are great, but because they involve engineering, they're expensive. So we're using the funds not to fill a black hole in the budget. We're using it to make our streets safer, right? And I really recommend that if any politician, if any community is looking at this, they talk with a consultant, one of our co-presenters who really knows this area of the law in other states and has experience with this law in other states, and that's Police Chief Glenn Thoroat. So he was going to be our presenter, but his plane broke down and the weather got bad, so he couldn't get here from out of state. So we had to kind of pitch in and give his side of as best we could, his side of the presentation today.
Some communities are turning to vehicle impoundment as a way to help curb reckless driving. So how does that approach work in practice? And then are there legal strategies that attorneys should consider when advising their clients or municipalities?
Right. So the use of vehicle impound law, that's another government sanction meant to deter bad behavior on the roadway, on their roadways. So when you're talking about government sanctions that are meant to deter, usually the more swift a sanction, more swiftly it's imposed, the more effective it is. So the idea is that, well, not many sanctions are more swift than towing someone's vehicle at the moment of the traffic stop for reckless driving. Unfortunately, or the reality is that under current law, you can't simply tow every vehicle used in a reckless driving offense. The city of Milwaukee currently uses 2 statutes to affect the impound of certain vehicles used in reckless driving offenses. Those would be 341.65 sub 2 and 349.115. The first statute I mentioned, 341.65 sub 2, that is a statute that's been on the books since 1991. That pertains to unregistered vehicles. The statute empowers municipalities to outlaw unregistered vehicles from being located on their highways, right? And it also empowers municipalities to remove those unregistered vehicles from the highways. So that's been there since 1991. In 2022, the city of Milwaukee adopted this policy to use that statute to target reckless driving. So now if you are a reckless driver, you're stopped for that offense of reckless driving, and your vehicle is unregistered, the vehicle will be towed pursuant to the statute I've described. So the legality of the tow is really based upon the unregistered status of the vehicle. Still, of course, there are many vehicles that are not unregistered that are used recklessly. Another statute that is currently in use in the city is 349.115. That was recently passed in 2023. That statute created a new class of vehicles that may be towed if they're used recklessly, regardless of their registration status. But if you read the statute, There are 4 elements that have to be present for a vehicle to be part of that class. And if you go through each of the 4 elements, you'll notice that it's quite a narrow category of vehicles that is created. First of all, the vehicle has to be used in a reckless driving offense, right? Second of all, the driver has to be the owner of that vehicle. Third, the driver has to have a prior conviction under 346.62 or a local ordinance in strict conformity with that. And then fourth, they have to have not paid their forfeiture for that prior conviction for reckless driving. So those all have to be present in order for a vehicle to be impoundable under 349.115, a narrow class created, right? And when you look at the numbers, the statistics of the vehicles that have been impounded pursuant to the 2 policies I just described, you see that the number of vehicles towed pursuant to the reckless unregistered policy since 2022, 608. The number of vehicles towed pursuant to 349.115 since its inception in 2023 is only 11 at this point. So that's an effect of the narrowness of the category that's created.
There are some efforts underway to broaden impound powers. So what obstacles have slowed adoption when it comes to that? And what kinds of changes are on the horizon that attorneys should be keeping track of?
So there is legislation currently pending in the Wisconsin legislature to expand the reckless vehicle impound ordinance. There's problems with that current statute that really limits how well it's been used. Under one statute, we've had something like 600 vehicles impounded, unregistered vehicles that are driven recklessly in Milwaukee over the last 2 or 3 years. Under this other statute, because it has so many detailed requirements before you can impound a vehicle, a registered vehicle, we've only had something like 11 vehicles impounded in the Milwaukee area. So the bill that's introduced currently would expand the ability of police officers to impound vehicles, registered vehicles. And I'm really proud to say that in the Assembly, that bill passed unanimously. When do we see bills other than let's create this state bird or this state insect? When do we see a substantive bill addressed in a real serious and somewhat controversial process pass one of our branches, legislative branches, unanimously? So I was really proud of officials that they could come together on this. And I'm hoping that the similar thing happens in the Senate in the fall. But I really encourage folks who are watching this, who have an interest in this or are concerned about reckless driving, if they have a senator who hasn't signed on as a co-sponsor of this reckless driver impound bill in the Senate, you could contact your senator about them. Tell them you're concerned about this. Tell them that you think this is one more tool in the toolbox of police departments any place in Wisconsin that they should have.
For attorneys who are looking at this issue, there's a lot to consider. What's the key takeaway for attorneys in Wisconsin when it comes to reckless driving?
I think the key takeaway is to keep in mind the immense cost that reckless driving, the toll of reckless driving on our communities, and sometimes that means that creative measures need to be taken to try to fight reckless driving. If you accept that, hey, this is resulting in the loss of life, this is resulting in enormous costs to communities and to taxpayers, then try to use creative ways to address it. And keep in mind the statutes that are at your use. The reckless driving statute itself, the penalty created for reckless driving that does allow for greater penalties and vehicle impound laws as well.
Don't accept the status quo, and don't accept the false information that's being put out there by opponents of better systems that could address this problem. We're going to smart technology, smart systems all over our society, right? In manufacturing, in retail, in transportation and logistics. Why are we adopting a 1901 approach to traffic enforcement when it's expensive, when it's ineffective, when we could do it in such a much better, more objective way, which would get more buy-in from the community if we went to a modern automated enforcement system. Change is possible. We don't need to accept the status quo, and we don't need to accept the Chicago model. Opponents of automated enforcement are going to keep hammering on the Chicago model. We don't have to do things the way people do in Chicago. Let's do it the way people do it in Colorado or Connecticut. Smart traffic enforcement, efficient traffic enforcement, effective traffic enforcement, effective in that it changes, it moves the dial on a culture in a community. So the default is a community that is complying with reasonable traffic regulations, which is to the benefit of all members of society. That's what we'd like to see. That's what I'd like to see.